The next case to come before the court is Weber versus Weber.
Morning.
Good morning. We're just a couple minutes early. You have any reason we can't proceed, or do you expect anyone else?
No.
You're here. No brief was filed on the other side, so you'll have 15 minutes to present.
Well, I hope not to take anyone here that
That's okay.
much time, Your Honor.
We're here anyways.
I'm here primarily to answer any questions that you have. I do want to say this is a matter of actually, I think, significant importance to Medina County because the state of the law, based upon the decision that I've appealed from in Medina County right now, is that upon a purge of the contempt, the aggrieved party has the burden of proving that the purge had not taken place, which I think is exactly the opposite of the law in the state of Ohio and presents a tremendous burden upon aggrieved parties. The vast majority of contempts in domestic relations court involve support. They're brought by the agency. The agency represents the aggrieved party, and there is no cost to the aggrieved party. But there are also a significant number of private contempts, such as this one. And for those people, it is an expensive and difficult process. And in this particular case, Mr. Weber has expended a tremendous amount of money and time and effort to try to be a father, a good father, and in difficult circumstances where his children were taken from the place where they were born and moved, I don't know how many miles it is to North Carolina, but a long way. And under those difficult circumstances, he has fought very hard to try to be a good father. And he went through all of the processes that I described in this brief to get to where he was, only to have, frankly, Mrs. Weber thumb her nose at the court. And he went the next step to have her held in contempt. But then, when it came time for the purge, he could interfere. And as I pointed out in my brief, the man has a child support obligation. It would be incredibly irresponsible of him to risk his job to come here. And come here for what? To prove a negative, which is impossible.
Do I understand, counsel, that you appeared at the purge hearing on behalf of your client? Or did no one?
No, I appeared on behalf of my client, yes, Your Honor. There were actually two hearings. The first one, one of my associates appeared at. That one was not reported, as I noted in the brief. I appeared at the second one. The evidence of a purge is peculiarly, which is a word that I've never been able to say, in the hands of the contender. And that is why it is logical and equitable for the contender to have the burden of showing that he or she is purged. The due process that a contender is entitled to has already occurred because he or she has already been held in contempt and after a full panoply of procedural due process. And at that point, they have, if you will, sinned, and therefore it is equitable that the burden to prove that they have purged their contempt is upon them. And as a practical basis, it almost has to be, because as I pointed out in the brief, many times obviously it's a matter of paying support, and there are records that the aggrieved party could present to the court and say, here's the CSEA record, he, she has not paid. In a case like this, the for instance, the one part of her purge, maybe the most important part, was to do what the court had ordered her to do 2 years earlier, which is send him an email every Sunday saying, here's what the kids have this week. Here's where their doctors are going to be, and here's the contact numbers, and here's that. And assuming that that did not happen, what proof was Mr. Weber to produce?
Let me ask you, it seems like the court, I don't know, maybe they're mixing apples and oranges, because at one point it seems like it's almost a penalty because he didn't appear, and he willfully and intentionally did not appear. The court says, therefore, you know, I have no choice but to find in favor of the wife. But then follows up with that saying that he wasn't there to provide any evidence that she didn't purge her contempt. So it seems like maybe two different things the court's saying.
Your Honor, you know, we're all human, and judges are human, just like anybody else. And
that's nice to know.
They are not.
You're right, we are all human, and we all make mistakes, but what's he saying, do you think? Is it the penalty, or is it an evidentiary issue?
Well, I mean, I think the judge was angry, and I think the court was angry. I think the court lost track of the law because the court was angry. I mean, you want my candid opinion, that's what it is. As a technical matter, while I certainly do not like resting on this argument, because that is not going to solve the underlying problem if the court were to focus on this in this decision, but as a technical matter, he wasn't ordered to be there. It's just not true. I mean... And
I was going to follow up that with that question, too. He said he didn't appear for the prior purge hearing. Was there a transcript of that hearing?
No one recorded. They never went on the record at that hearing.
Was there an actual hearing, though?
My associate and Ms. Weber and her attorney stood in the courtroom and spoke to the judge. In that sense, there was a hearing, but no one ever went on the record.
So if we look at the record here, which we obviously do, there's going to be notice of a purge hearing, and then there's going to be the next, maybe, I don't know the next, but sometime quickly on the record, there's going to be another entry that says that the purge hearing is continued.
That's correct. Actually, that entry is interesting because it says that Ms. Weber had not completely purged, and so therefore it was rescheduled for a later date, which is a conclusion that the court reached without even a record. So to then say subsequently that it could not find a failure to purge because he wasn't there seems a little incongruous. I have nothing further, Your Honors. If there's any other questions, I may have to answer.
I don't believe so.
Okay.
Thank you for your presentation to the court, your argument. The court will take the matter under advisement and send both sides a written opinion. And you can also look on the court's website.
Always do.
Thank you.
Thank you.